Hi, everybody. It's Elektra artist visa lawyer located in New York City. I am live today on TikTok and Instagram, Facebook, LinkedIn, etc., to talk to you about a request that I had, I think last night or early this morning, to talk about future work and itineraries and what that means in the O1 visa context. So, for those of you who don't know me, my name is Elektra. As I said earlier, our office is located in New York City. We're in Chelsea, um, a couple blocks away from the Empire State Building. So we're really in the heart of New York. We're across the street from FIT. We're close to all the major universities and all major forms of transportation. So, a lot of the times people will have this misconception of the O1 visa and think that it's really a self petition visa, which is not true. It's legally incorrect and it's practically false. So, when we think of self employment or self petition, we think that like you're basically here under your own auspices, right? That you don't have somebody who is petitioned for you, or you don't have somebody who kind of controls your or a person or a company that controls kind of like your immigration status. Your status is going to be tied to the work that you do and the petitioner that you have or don't have. So I just want to be very clear off the bat. This is not a self petitioning visa. This is not a freelance visa. This is not any of those things. And I think the issue with this is a semantics and language issue. Might also be cultural for some people, but even people in America think that. But basically, you're allowed to work for multiple people, places, things, projects, whatever. Your ability to work for multiple people does not mean that you are self petitioning or does not mean that you own the petition. When I say own the petition, I mean you do not have the right to withdraw that petition. The only person that has the right to withdraw the petition, so to basically to revoke your status, would be the petitioner, the owner of the petition that you are being filed under. So you're not petitioning for yourself. You're not. Your name is not on the immigration forms as petitioner. So that should kind of like clue you into the fact that you're not the petitioner, and thus you are not self-petitioning. Now, when it comes to the term like freelance and like work on your own, again, these are just semantics, right? You can, of course, work for multiple people, places, things. You can have multiple projects that you're working on. You can have one contract in your petition or 100 contracts in your petition. It really just depends on the nature of your work and how much people want to work with you, right? But for O1 purposes, what is future work? What is a future engagement? What does this even mean? Why do you need a job to be included in your petition? So this is important because your O1 validity period is going to be tied to your contracts. So if you submit a contract that has a one that lasts for a day, right? You're hired to do some sort of event, and that event is like a 2 day event, and you apply for the O1. That's basically going to be a 2 day O1 because your O1 is tied to the length of your contracts, right? So let's say you're like, hey, Electra, I don't have contracts. Like I can't file my petition. That's true. If there's no future work, there's no basis for a validity period. Therefore, there's no form that can be filed because we need to, by law, include a specific start date and a specific end date that is within this 3 year period because the O1 is maximum 3 years. So you can have a 1 day O1, but the maximum time period you can have is 3 years. Okay. So you need the contract to prove number one, that you're going to be working, so that you're going to be giving your artistic services to a company, a person, a place, a thing, a project. And number two, to establish the validity period, like the length of time that you're actually going to be working. So, what does the future contract look like? What is included in a future contract? So, future contracts have different sorts of clauses, right? And clause is just a fancy word to say different types of information, right, that are confirmed, memorialized within this document. So, the different types of information that can be included, or that should be included rather, is, for example, what sort of services will you be delivering? right? It's not enough for me to state that you are a designer or that you're an actor. I actually need to talk about this sort of work that you're going to be doing, right? As a designer, are you also going to be project managing or managing? Are you also going to be leading a team? Are you working on specific campaigns? Are you working on specific um, clients? I need to include those details within the contract because we need to actually show that you are giving you're executing rather your artistic services. Another thing that we have to include is how much you're going to be earning. Right now, this is actually really important because of two things. Number one, we cannot violate federal labor law. That basically means that you cannot be making less than $7.25 an hour. That would be a violation of federal law. And number two, we cannot violate state law. So we can't, in New York at least, I'm located in New York, you can't make less than $16 an hour. That would be a violation of state law. Now, each state has their different minimum wage laws. So wherever you are going to be working, you're going to have to adhere to that law. A lot of our clients, I would say most of our clients, are working in New York. So we adhere to New York state labor laws. Um, and number three, the contract is not only talking about how much what you're going to be doing and how much you're going to be making, but it's not a volunteer visa, right? You're not here to like kind of like volunteer your time out of your own goodwill, right? There are other types of visas for that sort of work. The O1 is a professional work visa, right? Should be very clear. Professionals are compensated for their time. Sometimes professionals will give their time for free, and that's a separate discussion. But for the O1 context, right, in terms of applying for the O1, you need to be compensated as a professional for your time. If none of those things are present within the document, this is going to raise red flags to USAS who already don't really understand what a contract or a letter of intent or deal memo or agreement or job offer actually means, right? This is why sometimes you'll see like blanket RFEs where you're like, didn't you look at the contract? Didn't you read the contract? It's your legal duty to do so, and you can always tell when they don't. So the future work component is really, really, really important, both for a technical reason, because we need to establish your validity period, and number two, for a substantive reason, because we need to prove your lead role, and we need to prove that you're working on some sort of reputable project or reputable company. I hope that that was clear. I hope that the things that are clear from this brief discussion is the necessity for future work, and that future work needs to be confirmed in some sort of document that is drafted. We can call it a contract so we understand each other. Drafted in some sort of contract so that USCIS can have proof that you're actually going to be working. So the contract establishes your validity period. The contract establishes the sort of artistic work that you're going to be doing. And the contract establishes that you are a professional, that you're going to be working on a reputable project, production, or company. Now, what is an itinerary? It's exactly what it sounds like. It's basically the sum of the different types of work that you're going to be doing. So, because, like I said, there's no limit to the number of contracts you can have. So, if a day has 365, a year has 365 days, you technically could have 365 contracts for 1 year, right? Does that typically happen? No, that does not typically happen. But it depends on your artistic profile, right? So, people who are more influencers, they're going to have a variety of different types of contracts that are mixed with, for example, events, brand partnerships, streaming collaborations. So contracts are going to look different depending on the industry. Again, you don't want boilerplate contracts. That case that I was talking about last night, I don't know if you guys remember, I was talking about somebody who went to another attorney, terrible outcome, came to us. Well, those were very like standardized, like she's going to be working here, she's going to be working there, like very basic contracts. And remember, the petition is synonym for persuasion. We need to persuade this. This is a discretionary approval. So you want to really work hard to persuade them to use their discretion to approve you. So that means that the contracts cannot just be A is working for B, A is working for 5 hours. They really need to be like fleshed out. Remember, these are legal documents determining a bunch of different things that we just talked about. You want to make sure that they are fully fleshed out. So the itinerary is basically like a cheat sheet or cliff notes that is basically summing up what you're doing, where you're doing, your professional title, and the location that you're going to be executing this professional services. This itinerary is a technical document, meaning that if you're filing an agent-based petition, and sometimes an employer-based petition, really just depends on how the contract is drafted, you need to include this. Right? It's a technical requirement, just like an advisory opinion is a technical requirement. It needs to be included within the petition. We can't just file without it. We need to give them that cheat sheet. We need to give them that information. So I think that when I got this question in our DMs, it was in regards to like what does it look like? Now, I can't tell you what it looks like. I can tell you the different clauses. I can tell you what might be included in it. But all itineraries are personalized to the individual, just like all contracts are personalized to the individual. The contract is really, like I said, proving a bunch of different things. So this is very just like everything in the O1, this is very strategic, right? You need to make sure that you are being strategic with the language that is being used. You need to ensure that the description and the descriptors of what you will be working on rise to the O1 legal standard. So for future work, there's no limit. You can have 365, but there are specific rules when it comes to an employer petition versus an agent petition. So with an employer petition, it's exactly what it sounds like. You're working for one employer. So you've got one job and you're stuck with them for like the next 3 years. Don't really This is a specific decision that you will make as long as you understand the limitations of an employer petition, which is basically like essentially you're stuck with them for the next 3 years. You can't do anything else beyond the work for them, for that one company. So you want to try to use a little bit of foresight and think about, what do you think might happen in the next 3 years? Do you think you might be stuck with one company? Or do you have different sorts of ambitions where you hope to have a multifaceted career where you have minimal professional limitations? Now, of course, if I file you as a makeup artist, you can't decide that one day you want to be like a dancer. I mean, they're two very separate fields. So those are the sorts of limitations that I'm talking about. But the limitations that people sometimes don't realize is, if I file you as an actor, but you actually also want to teach, you can't really teach. You've got to be filed as an actor and a teaching artist, right? You need to make sure that you are authorized to work in what you want to do. So that's why the contracts are extremely, extremely important. The contracts also feed into certain data that's going to go into the immigration forms. So again, this is the reason why it's important for the contracts to be analyzed properly. So when we draft the contracts, we are looking for a bunch of different flags, right? We're looking to see, do we have enough background information? Do we have enough of a description on the do we have enough of a description of the projects? Do we have a living wage? When I mean living wage, I mean according to the federal rules and according to the state rules. Did we include the agent clause? Is the agent clause properly drafted? Does this person have enough hours to have a full-time O1 versus a part-time O1? You can file a full-time or a part-time O1. It's better to file a full-time O1. So these are things that we are looking for, we are analyzing when we are drafting petitions. So I encourage you to continue to send me questions and to talk about the O1. Like I said yesterday, it's one of my favorite things to talk about. I have a lot of experience working with O1s, and I really just love this case type. I also really like talking about the business aspect and the business approach that an artist should have in her career. I think that a lot of the times we think that the law is separated from the arts, but really you can use the law and business to support the arts, to support your artistry, and to flourish within your field of endeavor. But I hope it was clear, the importance of the future work. I hope that it was clear the importance of understanding that this is not a self petition visa. Um, Again, I think that word is thrown out a lot incorrectly. There's a lot of nuance to the O1. I think I heard yesterday somebody, another attorney, talking about, well, if you own your own company, you can self petition. That's not true. You can't self petition with your company. Can your company petition for you? Absolutely, but your company is not going to be signing the immigration forms. Or I mean, you as the CEO or the owner of your company, rather, is not going to be signing the immigration forms. Right? You're not going to be the signatory to the immigration forms or to your offer letter. That would be nonsensical, right? You're going to sign your offer letter as the person offering the job, and you're going to sign the offer letter as a person accepting the job. This is why, again, very critical to understand the nuances. And once you understand, or you're working with somebody who understands the nuances, that's when you can really play around with the O1 and be very strategic, and for example, open up companies and have your company serve you for both your O1 and for your career. But again, not a self petition visa, even if you own your own company, even if you run your own company. I'm working with somebody very famous in his field, basically created the concept of content creation in his country of origin and has a massive company. We cannot use that company, right? It's not something that is permitted within the federal regulations, right? Or at least we cannot use the company as the petitioner, since he is the legal signatory to his company. So again, nuances, a little bit of trickiness, but not anything that an experienced O1 attorney can't navigate and properly advise you on. But what I want you guys to understand is not self-petitioned. You must include future work. That future work component is not necessarily tied to one company. It can be, but it doesn't have to be. And that's a strategy decision that you're going to make with your attorney. And number three, the itinerary is a technical document which must be included, and all the information within the immigration, within the or a lot of the information from the contracts and the itinerary will also be seen within the forms. So everything in the O1 world is very, very much interconnected, and makes sense, which is why within case law, you cannot obviously contradict yourself. So what I'm saying in the immigration forms cannot contradict the offer letters, just like what's in the itinerary cannot contradict what's in the contracts. If that happens, then you will be suspected of fraud. And fraud is something that is really hard to overcome. It's your burden as a petitioner. So again, this is something that is really important. I just received a list of companies that are flagged by USCIS for fraud. So there are certain companies that hire people in OPT that USCIS has kind of like red flagged and determined to be fraudulent. Um, this is why you want to be honest with the attorney that's representing you, and be forthcoming with the attorney so that the best strategy can be developed. So Kimberly on TikTok has asked, what shoes are you wearing today? Well, I'm in my office, and which is basically my second home. I know you can't see it, but there's a bunch of the awards and my degrees and stuff. But in my office, I've got slingbacks, heels, sneakers, and like open toed like sandals because of summertime. But today I'm actually wearing sneakers because it's Friday and there's a bunch of Halloween parties going on. For those of you who celebrate Halloween, and I'm going to a Halloween party tonight, so I kind of have to work efficiently to jet out of the office to go to the Halloween party. Does publishing content, videos, or music projects count as future work? I mean, it really depends. It depends. Are you being commissioned to publish that work? Probably. It really depends. The most important thing to realize, and I talk to my clients a lot about this, is that the work, everybody can create art. That sounds bad, but it really is the truth. Anybody can create something creative. Very few people have a professional finality to the work, that the creative work that they've done. And when I mean a professional finality, I mean it must be something that I can argue is an achievement. Again, If you look on my wall over here, I mean, I know you guys can't see it. Maybe I'll show people on TikTok. Like, I have a bunch of art on my wall. Does that art have a professional finality? Some of it does. Not all of it does. Does that mean it's an artistic achievement? Not necessarily. So anything that you are going to be doing for contract purposes needs to be commissioned. So like, you need to be hired. Somebody needs to want to work with you, and it needs to have a professional finality. The same thing with a portfolio. Again, anybody can take a picture, but if that picture does not have a professional finality, then it is not an artistic achievement for O1 purposes, which is what we need to argue. So, again, I can't give you a straight answer because it really just depends. It depends on the strategy. Like, a lot of the times I'll talk about visual artists. Like, if you're a visual artist, you're going to have relationships with galleries. But if you're a visual artist, you also know that the gallery is only going to pay you 50% once they sell your work. There's no guarantee that your work will be sold. I have clients who've been in galleries for years and they've never made money through the gallery, right? They make money through selling privately on their website and things like that, but not through the gallery. Now, in isolation, would I include the gallery contract? Probably not, right? It really is going to depend on the strength of the portfolio. So in isolation, probably not, but with other contracts, maybe. Again, it depends. So publishing content, if you're like a content creator and you're like, oh, well, I make money on YouTube, not going to rise to the level of the O1 unless YouTube is going to sign a contract that I draft, which they won't do. Because I work with a lot of YouTube content creators as well, and they just won't do it, right? It's not a part of their business model. So signing a contract is not something that would be appropriate for YouTube's business model. So, um, so yeah, I mean, that was a question that I got, like I said, either last night or early this morning. I can't remember. But if you want to continue to talk about things, just send me a DM, send me a message about specific things that you want to talk about. So again, I just want to be clear, like, I'm talking about, legal information. If you want personalized information with regards to your case, I cannot just give it on air. You have to either schedule a consultation or continue to watch our videos and talk to us and things like that. But I won't we don't do like a case analysis without a consultation. So yeah, I hope that this was helpful. I hope that you guys are going to have a great weekend. And my like little tip that I can't remember if I mentioned it last night, but something that is extremely important in life in general, but for the O1 specifically, is document, right? Document, document, document. You do not know what's going to happen in the future. You don't know if you're going to get fired. You don't know if you're going to stop a job, but document, 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 because you need evidence for your portfolio. So just as you're at home, thinking about your O1, or if you're at work thinking about your O1, screenshot, right? Screenshot things, and obviously make sure you're not violating any NDAs you may have signed, et cetera, et cetera. But make sure to save your work so that you can have data to construct and build your portfolio. So it was great talking to everybody today. The cases that we're going to file are in the conference room. So I'll make sure for the next live to have them in my office so that we can look at the sizes, because I think it's kind of actually extraordinary how big and how little some of these cases can be based on the legal arguments you're going to make. And not everything is kind of standardized. Everything is very different. So someone wrote, I'm currently in F1 and my master's. I wouldn't be able to, I am working with on, wouldn't be able to submit my petition as an artist because I'm working as a project manager. I mean, I don't know. Like, I'm able to see creativity and artistry in a lot of different things that people do. So again, if you want to have more of an in-depth analysis, you'd have to book a consultation. But I don't rule out O1Bs, even if you think that you are working in a field that doesn't use creativity. I'd have to ask the questions to figure it out. But I mean, I don't know. I can't say, oh, since you work in project management, you don't qualify for the O1B, because I've filed project managers successfully as O1Bs. But again, I have to know the case, I have to know the facts, I have to know the details to be able to successfully and with intelligence argue that you use artistry and creativity in the day-to-day work that you do. You probably do, you probably don't, you probably do, but don't realize, or maybe you don't at all. It really just depends. So I can't give you a straight up answer. And that's why I really like our practice and our law firm. Like, nothing is set in stone, if that makes sense. And none of our cases are cookie cutter. And that makes sense if you think about it, because life is not cookie cutter. Life is not black and white. Even me, myself, as an attorney, I use creativity in everything that I do, from the presentation and the organization of the finalized petition, to the arguments that we make, to the evidence that we use. So I consider myself very artistic, and I have a lot of different means to prove that I use artistry in the work that I do. Probably is the same for you. I don't know. You'd have to book a consultation. But anyway, great. I've been practicing art by my one since last 10 years. My job is completely different. I mean, it's great. 10 years is great, but it's not necessarily something that is going to get you an approval. It's not the years of experience. It helps because you have a lot of data. Like right now, I'm working on a very famous Nigerian artist who has 20 years of experience. But that 20 years of experience is beautiful, right? Because he's got press, he's got articles, he's got TV mentions, he's got beautiful work, major galleries. I mean, sometimes it helps if your work has a professional finality. So that's why I stress that you have to be very intentional with the work that you do. First, you have to do work. So you've got to accept work, whether it's paid, unpaid, etc. if you're on OPT. So you've got to do work. And then number two, you've got to make sure that it has a professional finality. I'll give you an example that is super common with actors, right? A lot of the time, an actor will perform in a film, and then I will ask that actor, like, hey, so what happened to the film? Oh, I don't know. Did the film have a professional screening? I don't know. Was the film selected and screened at different festivals? I don't know. So basically, you're telling me that film was for naught. If there's no professional finality, it's not, I won't be able to intelligently and creatively argue that that is an artistic achievement for O&B purposes. So sometimes years of experience helps if the work that you did was with intention and has a professional finality. So again, I love talking about this. I will see you guys, not tomorrow because it's Saturday, but I will see you on Monday to continue to talk about the O1. I might sprinkle in a little bit of like EB1As and EB2s. For those of you who are curious about EB2s right now, it's kind of like disastrous. There are lots of people filing EB2s that are not qualified. The priority dates are not current. So we anticipate lots of denials happening because there's just been an overwhelming number of non-STEM people and STEM people also, but non-STEM people filing for EB2s for which they do not qualify for. So maybe we'll talk about EB1As and EB2s because that's also a very interesting discussion as well. So have a great weekend, everybody. Enjoy your Halloween parties. If you guys are going to Halloween parties, I hope that you do. If you're in New York has a fabulous Halloween party, which would be like next week. But otherwise, document and work with intention. And I'll see you guys on Monday. Bye-bye.